Hello everyone, this is Crypto BitLaw back with another blockchain law, policy, and regulation update. Today is Monday, February 7th, 2022. As we can see, the major events happening in the digital asset space are that Tether's reserves are under question in a lawsuit that seeks information regarding those reserves, and CoinDesk recently intervened in that lawsuit. Nike files a lawsuit over the sale of unauthorized sneaker pictures sold as NFTs. An Ethereum name service, or ENS Director, was recently terminated over mean tweets that he sent out. China launches its CBDC, or central bank digital currency, during the Winter Olympics as U.S. lawmakers urge caution over the CBDC, or the digital Yuan. North Korea was recently discovered to have financed weapon programs with stolen crypto. And, as always, if you like this content, please smash that like button below and consider subscribing to our channel. We'd really appreciate that. You can follow us on Twitter. Our handle on Twitter is @CryptoBitLaw. And if you want to just jump around to any one of these stories, you could find that in the timeline below. So with that said, let's dive right on in. First up on the docket, we can see that Tether responds to CoinDesk's intervention in an ongoing reserves information case, under which the source and backing of Tether's reserves are in question in a case pending in New York. So the quick takes from this are that CoinDesk recently filed to become a listed party in an ongoing case regarding a Freedom of Information Law, or FOIL, request for Tether's reserves breakdown. Tether has responded to CoinDesk's intervention submission, claiming the conflict is between Tether and the New York State Attorney General. So what happens in an intervention, you can normally just start off with the original parties to the lawsuit, the plaintiff and the defendant. But if while the lawsuit is pending, another party comes along and says, hey, this is pending and the plaintiff filed the lawsuit against this defendant, but I actually have a stake in the issues that are subject to this suit as well. That third party can then file what's known as an intervention and intervene in the case. And if the court approves that, then they can become a party to the case as well. And then they would get all of the benefits in terms of discovery while that case is pending as well. And they can also be involved in any sort of judgments that are issued as a result of the case. So they become a party in the case. So continuing on, they say that Tether has responded to CoinDesk's intervention submission in the latest filing related to the Freedom of Information court battle, claiming the conflict centers on its settlement agreements with the New York Attorney General, not the arguments of the news outlet. CoinDesk formally joined the legal proceedings between Tether and the New York Attorney General last month, vying to become an official party in the case since its Freedom of Information Law, or FOIL, requests sit at the center of the dispute. In its latest filing, Tether argues that the conflict rests on facts of the agreement between the firm and the New York Attorney General, and that the news outlet shouldn't be able to, quote, renegotiate the terms by inserting itself into the case. So to give some context on this, the conflict began in June of last year when the news outlet filed a Freedom of Information Law request asking for documents detailing Tether's reserves breakdown. Tether and its parent company, iFinex, submitted this information to the New York Attorney General as part of a settlement agreement in February over the alleged commingling of funds. New York's Freedom of Information Law enables members of the public to request access to government records. At first, the FOIL officer denied the request, but CoinDesk won access on appeal. Tether responded by asking the New York court to compel the New York Attorney General to deny the request on the grounds that the requested information constituted trade secrets, could compromise its competitive advantage, and damage relationships. As the conflict centers on CoinDesk's request, the news outlet petitioned to intervene to become a stated party in the case, which allows it to present its own evidence and arguments. At the time, Tether responded in a statement pointing out that CoinDesk shares an investor, Digital Currency Group, also known as DCG. They share the investor with the stablecoin issuer and Tether competitor Circle. So, some context on that. Digital Currency Group, or DCG, is a investor in Circle, and DCG has investments. They are a parent company to both Circle and CoinDesk. So that's why Tether is firing back in their argument, saying, hey, there's a conflict of interest here. You know, your parent company, CoinDesk's parent company, also has a stake in Circle, which is a direct competitor to Tether. So continuing on, they say, after the statement, CoinDesk updated its coverage of the legal case with disclosure of DCG's investment. So, ooh, naughty, naughty. I think CoinDesk should have been a little more transparent up front, but let's continue on. Here are the arguments. Tether's filed response to CoinDesk's intervention makes similar mention of the alleged conflict of interest. Quote, while CoinDesk tells this court that it adheres to strict rules of journalistic ethics, its own reporting on this proceeding did not disclose to its readers this glaring conflict of interest until Tether and others complained, said the filing. Tether uses this support in its argument that the reserve documents do constitute trade secrets and could concede advantage to competitors like Circle. Quote, no private business would disclose publicly the investment strategies critical to its profitability and ability to differentiate itself from the competition, said the filing. Doing so would give the competition unfair insight that could be exploited. Furthermore, Tether contends that the powers to resolve the conflict remain with the New York Attorney General, since the settlement agreement it made with the office sets the terms of public disclosure. Tether contends that because the question at hand is whether or not the New York Attorney General should produce the documents, and CoinDesk does not have the power to produce those documents, it should not be on equal footing in the case. Because the New York Attorney General procedure initially rejected that FOIL request, Tether contends that the procedure should not be manipulated by CoinDesk's intervention. Quote, the only true respondents here are the ones named in the petition, the Office of the Attorney General and the individual appeals officer, said the filing. The court should therefore disregard CoinDesk's labeling itself as a respondent and at all events should not allow CoinDesk's misleading labels to alter the OAG's clear procedural default, which is grounds alone to grant the petition, to block access, that is. It goes on to point out that the material arguments are the ones centering on the existing settlement between itself and the New York Attorney General, stating, quote, CoinDesk should not be able to insert itself after the fact to essentially renegotiate the agreed terms. Now, my big takeaway from this is that although I agree with Tether in the sense that CoinDesk should have been more transparent in the fact that DCG, Digital Currency Group, was a stakeholder in CoinDesk, and there is a connection between DCG, CoinDesk, and Circle, which is a competitor. I think that that's almost like a red herring. I think that the real issue here is that Tether is fighting tooth and nail to keep its reserves, the information about those reserves, private. Because we all know, I mean, these things are backed with pretty much, they're backed with commercial paper, but I suspect the value and the grade of that commercial paper is garbage. Right? And Tether just kind of keeps printing. They're acting like, the Fed or the United States government, just printing money to high heaven on a whim, backed by nothing. And if people really catch on to what the hell is actually going on with Tether, and there's actually any sort of, meaningful, mindful reaction to this, people actually wake up and realize what's going on, that they're trading in a stablecoin that's backed by essentially nothing, then there could be a run on Tether and it could lose its peg. I doubt that's ever going to happen. One of the main reasons is I guess there are two. Tether is fighting and to this date has hidden what's actually backing these things, the outstanding Tether in its reserves, and they've got a good clamp down on that information. And second, you can redeem Tether for actual US dollars, and certain entities claim to have done that in the past. But the likelihood that retail investors or just, the majority of Tether users in general would actually go to Tether and try to reclaim US dollars for their Tether and exchange their Tether for dollars is virtually nil. The likelihood of that happening is slim to none. So, all said, I think that, yes, Tether is trying to protect the secrecy of what the hell is in its treasury at all costs, and CoinDesk, maybe through acting as a proxy of DCG that does have tentacles in Circle, which is a Tether competitor, is trying to eke out information. But I think ultimately, all in all, I think transparency is a good thing. Sunlight's the best disinfectant, and I think everyone deserves to know what the hell's going on with Tether's. Just as an aside, if you'd like to see CoinDesk's take on this situation, I've linked the article down below, but the source that we covered was a third party just because I thought that it would be a little more transparent. That's why we went with the block's take on it as opposed to CoinDesk. But if you want to hear what they say about it, CoinDesk, that is, right from the source, you could find that below in the description. Next up, we can see that Nike sues StockX for selling unauthorized sneaker pics as NFTs. Some of the unauthorized Nike NFTs are being sold at triple the value of the actual sneakers. Decrypt reports that Nike has filed a lawsuit against online sneaker reseller StockX at a New York federal court today, alleging today being a few days ago, February the 4th. But continuing on, they say Nike alleged that the Detroit-based vendor has been selling images of Nike sneakers as non-fungible tokens, or NFTs, without authorization. Since January, StockX has sold a variety of sneaker-themed NFTs as part of its, quote, vault collection. The NFTs are openly modeled on real sneakers, and Nike complains that StockX has told buyers that the unapproved NFTs will be redeemable for physical goods in the near future. The complaint says that StockX has sold over 500 Nike-branded NFTs since launching its blockchain, quote, vault venture on January 18th, sometimes banking more than triple the value of the NFT's official physical counterparts. Nike's filing argues that this is a clear case of copyright violation. And this isn't really actually correct, because I actually went through the complaint, which is over here. And what they're actually alleging, it's a trademark violations and causes of action that sound in trademark law and unfair business practice, things like trademark dilution and so on and so forth. But, copyright law also sounds in intellectual property law, but that's kind of a newbie or pleb mistake right there. But you could actually go through the complaint right here. It's going to be listed down below, and as well as the docket, which is also listed down below. But continuing on, the complaint argues, quote, those unsanctioned products are likely to confuse consumers, create a false association between those products and Nike, and dilute Nike's famous trademarks. Here is a picture, as we can see, of one of these NFTs that are being sold on the StockX site. With a market valuation of $3.8 billion as of last April, the resale platform deals in everything from electronics, streetwear, and collectibles to watches, handbags, and even Bored Ape Yacht Club physical collectibles. In November of last year, the sports apparel firm submitted 4 filing requests to trademark virtual goods with the U.S. Patent and Trademark Office. Later that month, it built a virtual headquarters in Roblox, an immersive 3D, though not blockchain-based online multiplayer game. And the big takeaway from here is that Nike's latest legal action is yet more evidence that these companies are taking the digital world very seriously. Now, what really strikes me in all this is the speed and just the haste at which Nike was able to, A, recognize this infringement, and B, file a suit in the Southern District of New York following becoming aware to it. I think that they only just started listing these things. StockX did these unlicensed NFTs on January 18th, right? And so, I mean, it feels like it hasn't even been a month since that, since Nike became aware of it and actually filed this suit, or filed this complaint, opening up this lawsuit. And ultimately, what I think is going to happen is Nike is going to win this. I mean, this is as clear-cut as it gets for me, in my opinion. I mean, if that is Nike's trademark brand right there, I mean, that is the clipped wing of the goddess Nike, and that is their trademark. And they lay it out right here in black and white. They are going to win. There is little doubt in my mind. Whether it actually goes to trial, whether the merits of this come out at trial, or they'll probably end up settling before that. That's usually what happens. I mean, look, these are the trademarks right here. And clearly this company is using it. So, I mean, this is a no-brainer. But I think it's really interesting to start to see this wave of lawsuits that are popping up that they question or they attempt to resolve issues that arise at the intersection of NFTs in the blockchain and digital space and things that exist in the actual real physical world. So, interesting development. If you want to learn more about this, I've listed the docket here. There's no real main developments. It just notes that, hey, the complaint was filed on February 3rd. And the only real developments were notice of appearances and opening statements, and then I guess an order for a pretrial conference, which is coming up. But, I mean, this is going to play out for a while. We'll keep you up to date on this. We've got alerts on this docket. And if you want to see the complaint, that's actually listed down below in the description, too. So moving on to our next issue, an Ethereum name service executive or director was recently canceled over mean tweets. Decrypt reports that an Ethereum name service nonprofit terminates Brantley Milligan, that's the director. They terminated his contract over tweets. After a controversial tweet resurfaced, the legal entity backing the Ethereum name service has terminated its contract with Brantley Milligan. The report states that the legal entity that leads development of the Web3 app Ethereum Name Service, or ENS, True Names Limited, TNL, has terminated Brantley Milligan's contract this morning. Milligan is the director, or was the director of operations at ENS, a solution that turns complicated Ethereum addresses into easily readable .eth addresses. So that's kind of analogous to what's known as the DNS servers, domain name server, that translate these easily readable web addresses. So decrypt.co, normally that would redirect to an IP address, a series of numbers that are very hard to remember and not easily exchangeable between people, but that's what the DNS does. The ENS service does the same thing, but with Ethereum addresses, where you have this, pretty much this hash, this series of hex, letters and numbers. It translates those addresses into something that's easy to read, like, Brantley.eth or whatnot. But continuing on, they say that TNS, the nonprofit that funds and organizes the development of ENS, has terminated the contract of Brantley Milligan effective today. Read a tweet from Nick Johnson, the lead developer behind ENS. TNS's move follows a backlash stemming from the reemergence of a controversial tweet from Milligan. We could see, continuing on, they say, many of you were hurt by Brantley's comments over the past 24 hours, and we strongly believe that ENS should be an inclusive community, added Johnson. So here we could see, a member of the mob kind of coming after him and, trying to cancel him. And here were his tweets. First, we'll see what they say, and then we'll check out the tweet. In May 2016, Milligan tweeted that homosexual acts were evil, denied the existence of transgenderism, claimed that abortion was murder, and described contraception, masturbation, and pornography as perversion. So here are the actual tweets, and he actually said those things pretty much verbatim, which is, kind of shocking. Okay. He has continued to defend these views publicly, responding to calls that he addressed the comments with, quote, not really anything to address. I adhere to the world's largest religion, and apparently that's not allowed in Web3. Well, I don't know. I'm not going to touch any of that with a 10-foot pole. I'll just say that. This is just what he did and how this is playing out. Milligan has also been removed indefinitely from his position as community steward by the ENS DAO following a vote within the community. An ENS steward is elected to the role within the DAO responsible for managing its operations. Following his removal, another proposal outlined the next steps and included potentially removing him as a director of the ENS Foundation and asking Milligan to step down from his leadership role in the ENS. So, interesting, even though Web3, as it is popularly becoming known as, blockchain-related technologies and digital assets, even though it's decentralized and you have things like DeFi and DAOs, and, more often than not, you can have situations where there's no real central authority that controls these things. Despite all of that, this is a pretty black and white case that, your actions can have consequences. You can be canceled for things that have happened in the past, even though you exist in this, decentralized, trustless world. So just a cautionary tale, a word to the wise, watch what you say, because, what you say can come back to haunt you. Here we can see that CoinDesk reports that Senator Toomey sounds a warning about China's digital yuan as the Olympics start. The country is using the Winter Olympics in Beijing as an international test of its central bank digital currency, or CBDC. They say Senator Pat Toomey, a Republican from Pennsylvania and a ranking member of the Senate Banking Committee, warned of the impact of China's digital yuan on U.S. economic and national security interests in a letter to Treasury Secretary Janet Yellen and Secretary of State Antony Blinken on Friday. Quote, analysts have raised the ECNYs, or this is actually just the ticker for the digital yuan, ECNY, have raised the ECNY's potential to subvert U.S. sanctions, facilitate illicit money flows, and enhance China's surveillance capabilities and provide Beijing with a, quote, first-mover advantage, such as setting standards in cross-border digital payments, Toomey wrote. China is using the Winter Olympics in Beijing as an international test of its digital yuan, which it has been testing in the country since 2019. In the Olympic Village, athletes and visitors can make purchases only with cash, a Visa card, or the digital yuan, Toomey noted. Toomey added, however, that China's crackdown on private cryptocurrencies gave a potential opening for the U.S. Quote, China's crackdown presents an opportunity for the United States to become the forerunner of crypto innovation, grounded in individual freedom and other American and democratic principles, he wrote. Toomey has asked the Treasury and State Department to scrutinize Beijing's digital yuan rollout during the Olympics and provide a full briefing by March 7th. So I'd be really interested to see when that briefing drops and check out what's inside. But if you'd like to check out a letter, here's a copy of the letter that Toomey wrote to Blinken and Yellen. It's going to be linked down in the description below. It's interesting. It pretty much everything that's in here was covered in the previous article, but Toomey isn't the only one that's actually criticizing the digital yuan. Apparently, Minnesota Representative Tom Emmer, who's a member of the Blockchain Caucus, threw his hat to the fray as well. Quote, do not accept any digital yuan, said Minnesota Representative Tom Emmer in a tweet aimed at Team USA athletes competing in China. Cointelegraph reported that many U.S. lawmakers are offering their support for those competing at the games, with some, including Minnesota Representative Tom Emmer, offering a last-minute warning to athletes to not use the digital yuan while in China. Emmer has previously referred to China as living under, quote, digital authoritarianism in proposing legislation to limit the Fed's ability to issue a CBDC. Here's the tweet from Tom. Good luck to all Team USA athletes competing in the Olympics. Word to the wise, do not accept any digital yuan. Solid advice, man. In July, a group of 3 senators sent a letter to the U.S. Olympic and Paralympic Committee claiming that the Chinese Communist Party could use the CBDC to surveil visiting athletes both while at the Games and upon their return to the United States. The committee reportedly suggested members of Team USA leave their smartphones at home and only use, quote, burner phones while in China, given the former could be infected with malicious software. At the time of the publication, the Team USA Instagram page continues to post its own stories and share those from participating athletes' accounts. They say the Beijing 2022 Olympics is the first major testing ground for the country's CBDC among a broad group of international visitors. Since its launch almost 2 years ago, transactions using the digital yuan have totaled more than $13 billion, with roughly 10 million merchants activating digital wallets for the CBDC by November 2021. So, I mean, I think that this is solid words of caution, from these lawmakers. I think that they know exactly what's going on here. I mean, there is no doubt in my mind that the Chinese Communist Party would input some sort of malware or surveillance software in the digital wallet held on the phone in order to track people that are engaging in transactions with this digital yuan. I don't like anything about it. I don't trust the Chinese Communist Party as far as I could throw them. If you look at what they did, not only first, I mean, how many times have they banned crypto mining? Then they finally banned it for good. And then on top of that, they actually banned transacting in crypto in general. And so as a result of that, all of these Chinese miners and crypto holders migrated to decentralized exchanges, in particular DYDX. All of these funds, just overnight, once this ban came down, they all moved their funds. Not all of them, but most of the funds were moved to these decentralized exchanges. Why? Why did they do that? Clearly, China wants total hegemony over any sort of digital asset in their country because they want to control the flow of money. Anything that isn't within their control, not under the Great Firewall of China, that they don't have complete totalitarian level control over, they outlaw, they ban it. I mean, it's literally, like this guy said, digital authoritarianism. Don't trust it. It's the antithesis of freedom in a free market system. I think it's good that people are actually raising these issues, in particular lawmakers that are raising these issues and sounding the alarms to the rest of the world. Can't trust this stuff as far as you can throw it. Bad news bears. Not. Finally, we could see that North Korean nuclear weapons programs were financed in crypto, according to a report from Reuters. A United Nations report has found that the nuclear and ballistic missile programs in North Korea rely on financing from crypto. Now, that's kind of fuddy, that fuddy title. I think the better title should be financed from stolen crypto, would be the more appropriate title for that. But continuing on, Decrypt says that North Korea's nuclear and ballistic missile programs rely heavily on revenue from cyber attacks and cryptocurrency exchanges, according to a United Nations report seen by Reuters. And here's the report if you'd like to learn more about it. It's pretty interesting stuff. It's going to be linked down in the description below. Continuing on, they say, according to a member state, DPRK, that's the Democratic Republic of Korea, cyber actors stole more than $50 million between 2020 and mid-2021 from at least 3 cryptocurrency exchanges in North America, Europe, and Asia, the report said. Last month, Chainalysis data, which was also cited in the UN's most recent report, found North Korea to have launched at least 7 cyber attacks against cryptocurrency exchanges. This activity generated almost $400 million worth of cryptocurrencies for the Hermit Kingdom. Chainalysis also found that once North Korea gains access to the targeted funds, the regime, quote, began a careful laundering process to cover up and cash out. In 2020, a report found that North Korea was also pivoting to Monero, a cryptocurrency designed to be totally anonymous. Quote, we believe that Monero's anonymity and lower processing power requirements likely make Monero more attractive than Bitcoin to North Korean users, the recorded Future report said. In 2019, the UN estimated that North Korea had generated about $2 billion for nuclear ballistic missile programs. Now, is it really a surprise to anyone that North Korea has and will continue to engage in this level of hacking and criminal activity, and then use the funds that they garner from those nefarious activities to fund things like their weapons programs? I mean, that's a no-brainer. It's also a no-brainer that they're going to favor privacy-based coins like Monero in order to cover their tracks and effectively clean and wash the money that was stolen to finance their weapons programs. I would be surprised if they aren't also using things like Zcash and on the Ethereum chain, Tornado Cash, in order to clean and wash and launder the ill-gotten gains. None of this is surprising. I think that this is pretty much a no-brainer, but it's interesting that we actually, are seeing these types of stories pop up in the popular major news publications, and it's actually being considered by these global operations like the UN, where they're trying to figure out, like, hey, where are these rogue nations actually getting their funds? How are they using them, and how are they being transferred? How are they laundering them? What is the actual process by which these rogue nations are getting access to these funds? And it's one of those things, I mean, the more that you know about it, the better you're able to adapt and react to it. But, I mean, it's a no-brainer. I mean, they were smart to use Monero and all of these other, mixing services or privacy-based coins like Zcash or Tornado Cash in order to clean and wash the stuff, which is why I hate to keep bringing it up. It's that whole Colonial Pipeline hack, where, these hackers were smart enough to hack the Colonial Pipeline, then get a ransom in Bitcoin, but not smart enough to mix it or tumble it or clean that money. And so that they were tracked by government officials based on the transaction history on the blockchain, the Bitcoin blockchain ledger. So, even these North Koreans are smart enough to clean their tracks and wash the money appropriately. That's why, I'll say it once, I'll say it again. Nothing about that Colonial Pipeline hack adds up, but 'tis neither here nor there. Just an interesting point that, here we have this report pretty much stating the obvious. North Korea continues to hack things. They steal people's money in the form of crypto, wash that crypto, and then use it to fund things like their weapons programs. So I can't say anybody's really shocked at that, but all in all, those were the major events that have happened over the weekend and recently in terms of the blockchain legal, policy-related, and regulation space. I hope you guys enjoyed this content. If you liked it, please hit the like button below. Please also subscribe to our channel. We'd really appreciate that. Again, you can follow us on Twitter. We are at CryptoBitLaw on Twitter. And with that said, thanks again for watching, and we will see you guys in the next